Our first featured speaker of our program today is Burrell Ellis. Mr. Ellis served 5 terms as the DeKalb County CEO, which is similar to being County Commission Chair here in Gwinnett. In 2015, he served time on a conviction that was later overturned. Mr. Ellis was named the ACLU of Georgia's first political director in 2016 and led its Smart Justice campaign. More recently, he's been on the task force assigned to repurpose the Atlanta City Detention Center into a community resource center. Please help me welcome to the stage, Burrell Ellis.
Good afternoon, everyone. Thank you, Anthony, for that warm introduction. I think you extended my term in office a little bit longer. It wasn't 5 terms, but I did. I was blessed to serve 2 terms as DeKalb County CEO. I want to thank the Greater Gwinnett Reentry Alliance for the good work that you do to provide opportunities to our returning citizens. I want to acknowledge Governor Deal. Thank you for the work that you've done around this important issue of reforming our criminal legal system here in Georgia and the work you continue to do. I want to acknowledge all of our distinguished guests, our elected officials, our law enforcement, and everyone who's here today. I too am on a time frame, and so I want to jump right in to my topic today, which I have titled, A Better Chance for All. A Better Chance for All. We are living in a time of dramatic change, a time when we are facing questions about what it means to live in a nation of laws within a free society, a time when we question what it means to live in a democracy and which laws continue to have relevance to our modern day lives. Freedom of speech, equal protection under the law, protection against unlawful search and seizure, the right to privacy, due process, the presumption of innocence, the right to consult with an attorney, the right to present relevant evidence, the right to cross-examine witnesses and testify on one's own behalf, the right to a fair trial, and the right to be informed of one's rights, the promise of liberty and justice for all. These are all fundamental guarantees under the United States Constitution. They guarantee individual rights that protect us from tyrannical rule, which many Americans seldom have to think about and likely take for granted until needed. Each and every one of these guarantees was denied to me when I was wrongfully prosecuted of trumped-up charges by a local district attorney with unbridled political ambition. I wasn't accused of stealing or misappropriating any money, nor was I charged with public corruption. The district attorney intentionally misled a group of everyday citizens sitting on a grand jury into believing that a perfectly legal and common practice, campaign fundraising, amounted to a crime. There were 15 redundant and deceptively worded charges in all, such as theft of services and attempted extortion. At the time, I was the top elected official of a large metropolitan county, overwhelmingly elected twice by the people of that county. I had been elected by my peers from across the country as president of a national advocacy organization, the County Executives of America. And I had an ongoing and constructive working relationship with the Obama White House. At that time, I had been an attorney licensed to practice law in Georgia and the District of Columbia for almost 30 years without a single ethical blemish on my professional record. At that time, I had graduated from an Ivy League university and a top-ranked law school. At that time, I was an active citizen and volunteer, devoting countless hours of service to my church, to my community, and to civic organizations such as the Boy Scouts and Big Brothers. At that time, I was an active voter, never missing an election, even if it was a special election or a referendum vote where no one was even running for office. At that time, I was a husband, a father, a breadwinner for my family, and a supporter of worthy causes. And at that time, I had never once in my life been in trouble with the law. Yet, based solely on the accusations alone, I was suspended from office without a trial and without being convicted of any wrongdoing. So much for due process or the presumption of innocence. Once in court, the judge expressed concern about the district attorney's political antics. The judge stated that even he could no longer trust the DA's office. The DA responded by suing the judge and serving him with notice of the lawsuit in open court while the judge sat on the bench. The judge was then forced to hire a lawyer to defend himself against the DA's lawsuit. Eventually, the DA was able to wiggle enough room while tying up the judge's hands to bring an indictment against me and get a new judge appointed to oversee the case. The new judge was a former employee of the DA's office who shared political alliances and sentiments with the district attorney. Now feeling in control, the district attorney offered me a plea deal. Pick a misdemeanor, any misdemeanor. I was told by my attorney that the DA said it could be spitting on the sidewalk. And the DA added one more stipulation: resign from office. I rejected that deal and all future plea offers because I hadn't done anything wrong. The district attorney did not like my response to his offer, so he threatened to bring more charges, and he delivered on that threat. Eventually, my case went to trial twice. In the first trial, the prosecutors filed a barrage of motions to stop me from presenting evidence in my defense. They filed a total of 19 pretrial motions in all. The judge granted 18 of those motions in their favor. The purpose of a trial is to allow the jury to hear all relevant facts and then make a truly informed decision regarding guilt or innocence. But without an opportunity to tell my side of the story, it ended in a mistrial. Considering the way they had stacked the cards, that was a major defeat for the district attorney, and he seemed to take it personally. So he decided to retry the case. In the second trial, the prosecution filed even more motions asking the judge to further limit my defense. And this time, the judge declined to rule against even a single one of the prosecutor's numerous and usually absurd requests, including their motion to stop me from holding my wife's hand during court recesses or to gaze lovingly into her eyes. The judge used that opportunity to chastise and caution us to not prejudice the jurors who might see us holding hands or gazing as couples do. Throughout the entire trial, I was referred to by the prosecutors as a criminal and a liar without any rebuke from the judge. So much for not prejudicing the jury. As an added measure to shut down our defense, the prosecutors asked the judge to put my lawyers under an order of criminal contempt of court. And once again, the judge assented. That meant that my lawyers were working under the threat of being removed from the courtroom in the middle of the trial and sent to jail if they even mistakenly made reference to an item in my defense that the judge had forbidden. My defense team was in effect handcuffed. This should be unheard of in a court of law in the United States of America. It was like walking on eggshells. In spite of such enormous obstacles, I was acquitted on most counts, but not all. I was found guilty on 2 of the charges, and after the trial, one of the prosecutors publicly bragged about how much control they had over the judge. And despite my record as a leader and upstanding community member, without any criminal history or threat of violence, the district attorney asked the judge to send me to prison merely because I had refused to accept his plea offer and elected to exercise my constitutional right to go to trial. And once again, the judge agreed with the prosecutor. I was denied an appeal bond and put in immediate custody without any opportunities to make arrangements with my creditors, kiss my wife goodbye, or let our 2 young children know that Daddy isn't coming home for a while. I received a 5-year sentence. This time, the judge actually deviated from the district attorney's request. He had asked that I be sentenced to 10 years. I was incarcerated for 8 months before being released on parole. I was sent to a state prison. It was not a country club experience, as some have imagined. Prison is a dangerous, brutal, and inhumane environment. To send someone to prison who poses no threat of harm to anyone is a reckless act. It puts their life at risk. 2.5 months after my release, the district attorney ran for re-election. By that time, I had been stripped of my right to vote, but not my political activism. My family and I campaigned vigorously to elect someone to office who would serve with honor and respect for the people. On the night of the election, my wife and I went out on a date to celebrate the outcome we believed would come later that evening, and it did. The incumbent district attorney was soundly defeated by a margin of almost 2-1. Many voters expressed outright dissatisfaction with the manner in which he had unjustly attacked me and my family. Even now, I hear those same sentiments almost daily. 6.5 months later, the Supreme Court of Georgia unanimously reversed the conviction, citing the unfairness of the trial and my inability to present evidence to defend myself against the charges. One of my lawyers estimated that the Georgia High Court reverses fewer than 5% of all criminal convictions, and even fewer by unanimous decision. But because this was such an egregious violation of the Constitution, a mostly conservative Georgia Supreme Court was compelled to take action. Even then, the stiff-necked, stubborn-minded DA attempted to stall the outcome by asking the Supreme Court to reconsider its unanimous ruling. Within 48 hours, the court rejected that motion and again ruled in my favor, unanimously. By then, we were into the final month of my second term of office. I had been suspended from office for all but 6 months of a 4-year term. With just 17 days remaining in my term, I returned to office. In all of my studies of politics, I have not heard of another American elected official who has been maliciously indicted, tried as a criminal, wrongfully convicted, denied an appeal bond and then imprisoned, and then, after having the conviction reversed, returned to the same term of office from which he or she was removed. During my final days in office, I worked with our county commissioners and professional staff to address blighted neighborhoods, develop a solution to a water management crisis, organize a standing room only ceremony recognizing 25 outstanding citizens, assist my successor in the transition process, and I personally visited each of our senior centers, among other things. It was an active and invigorating time in my life. On December the 31st, 2016, my final day in office, I worked until midnight. My last official act was to present a proclamation to my church for its service to our community. A few months later, the newly elected district attorney evaluated the case and dropped all charges. My voting rights were restored, the suspension on my license to practice law was lifted, and the county made a gracious decision to reimburse my back pay as well as my out-of-pocket legal expenses. Thank you. Thank you. This is my story. I'm in the process of writing it in memoir form, which I hope to have published in the coming months. It's an important story to share because it illustrates, in many ways, the brokenness in our nation's criminal legal system. It is not a system built on justice, and that's why I don't call it a criminal justice system. It's a system designed to punish. We cannot adequately reform it until we address its underpinnings. What are the societal costs of thoughtlessly separating a family by removing a responsible, tax-paying head of household who poses no threat of harm to anyone and sending him to jail or prison simply because we can? We should expect the role players within the system, our judges and our district attorneys, to govern not just with their heads, but with their hearts, to care enough about restoring human lives to pursue a higher standard when they are capable than incarceration and destruction. Our criminal legal system is a system rooted in racism. It is a betrayal of America's promise of liberty and justice for all. It is a system that disproportionately targets and punishes people of color and then puts them into a permanent underclass where they are legally discriminated against and denied the rights of full American citizenship. We all bear a responsibility here. We cannot offer people a better chance while denying them an equal opportunity. We must remove discriminatory barriers to reentry, restore full citizenship rights, and raise thoughtful questions regarding why those rights were removed in the first place. In many ways, I am one of the fortunate few. My family stood with me and stayed together. I got my job back with all back pay. I got my license to practice law back and, along with it, my ability to make a living. I got my reputation back. I was exonerated by the Supreme Court of Georgia, and my legal fees were reimbursed. One could make the case that I was innocent from the beginning, but so are many others who never received justice. And what about those who made mistakes and then paid their debt to society? Do we not now owe them the chance to live the remainder of their lives on the right path, lest we all suffer the consequences? As a blessed and enlightened society, we should exhibit grace. We cannot hope to offer a better chance unless we are invested in building a better world. We cannot allow our frustrations and disappointments with the way things have been to cause us to check out. We must fight to build a better world with better chances for ourselves and for the next generation. And because it's already 2020, we must remember to take our fight to the ballot box. This is why voting matters. Because elected officials make and enforce the laws that determines who gets arrested, who goes to jail, who stays in jail, and who is denied opportunity when they are released. Elected officials determine whether and how those individual liberties embedded within the Constitution are enforced. Elected officials decide who actually gets justice and how it is dispensed. So if we're going to build a better world with better chances, we have to raise the right questions of candidates for office and then get out and vote for the ones who set the right vision. Voting for president is important, but voting for president alone is not enough. Voting for governor or mayor is important, but voting for governor or mayor alone is not enough. We must also vote to elect state representatives and sheriffs and judges and district attorneys who are reform-minded. Our criminal legal system is a multi-headed hydra. Reform will come from many approaches, and we all learn from our personal experience. Here's one thing I learned. There is a vast amount of unchecked power that lies in the hands of district attorneys. That power is often abused in ways that are hidden from public view. And when it is abused, it is disproportionately targeted against people of color because the system is designed that way, irrespective of the color of the prosecutor. So, it's not good enough to vote only for the people running for the most popular offices. Those people hold lots of power, but we can't stop there. It's not good enough to elect someone based solely on what they look like. Sometimes that makes us feel good, but we have to require more. We must vote responsibly for people based on what they stand for. And if we do that in 2020, we will build a better world that lives up to America's promise: liberty, justice, and a better chance for all. God bless you. Thank you.